So today's topic is negotiation, right, which stems from chapter 3 in your textbook. Um, Negotiation is our first line of defense, right? It's our first form of ADR, in which the parties usually try to work out some kind of resolution and some kind of dispute between themselves, right? They're like, okay, we don't need a third party yet. Right, then we get to mediation. Mediation is we brought in a third party. The third party is here to help us come to our own conclusions. Then when we get to arbitration, arbitration is we brought in a third party. The third party is going to tell us what to do, right? Regardless of maybe how we feel. So we're starting with the negotiation. The parties working it out themselves. We're going to start kind of from a baseline, and then we'll get into some of the hallmarks of what a good negotiator does. So again, normally we do a talking circle. We'll save it for the end if we have time. Now, before we begin negotiation, you as a prospective negotiator have to understand the difference between positions and interests, right? So, you know, if you've ever, I mean, if you read the Getting to Yes book, right, it tells you you're a negotiator, whether you like it or not. And it's true, you negotiate things daily. But it's difficult for us to always get what we want, or difficult for us to even make progress a lot of times, right? And it's because we're focusing on people's positions, not on their interests. So a position is going to be the formal stance taken by a party as it relates to some issue subject to negotiation, right? It's their formal stance. The party's formal stance. So for instance, let's say that you're at a secondhand shop, or you're trying to buy some kind of like antique, right? Often positions are postulated as non-negotiable, right? So you would enter the negotiations, the person looks at you and says, the price is $500. I'm not going to take a penny less. The price is $500. Their position is the price is $500. That's their position, right? Most of the time we leave it at that, and then we start like trying to dicker and whatnot at $500 and try to get that down as low as we want to go, right? Because our position is we want the antique, but we want the antique for the lowest price that we can get. Their position is they want the $500, right? That's all you know. So you can try talking them down like, oh, $450, whatever, but you likely won't get to your best price that way because you're just looking at their position. Looking at their interests is a little bit deeper, right? It's more kind of psychological based. So it's the why behind the position, right? So like the example I have here, how did you arrive at $500, right? Their answer, it's what I need in order to appease my boss. Okay, so now you know the issue is not $500, right? The issue is they want to impress their boss or keep their boss happy. So once you understand somebody's interests, then you can start the negotiations, right? So asking why, asking how, again, in a professional tone, not, well, how'd you come up with that? But can you explain to me how you arrived at the $500 figure? They're going to let slip something because we as people are not used to getting to interests, right? We're used to just dealing with positions. So easiest way to get somebody to reveal their cards is ask them why, right? A simple question of why. Because if you see this, I mean, this is just one example, right? You know it's not about the $500. It's about this person needing to please their boss. Well, then you can respond back with, well, wouldn't your boss like to see this off their inventory? Right? numerous ways that you could respond that will ensure that you get what you want for the price that you want, right? Your goal is to figure out how this person now can please their boss without having to pay $500, right? So that kind of behooves you. It puts the pressure on you to figure out how you make this solution work. And we're going to talk about being a creative negotiator in a moment. So that being said, your text presents two approaches to negotiation, right? So there's two primary approaches. There's the competitive approach and there's the cooperative approach. I would argue there's actually three primary approaches to negotiation: the competitive approach, the cooperative approach, and the creative approach, right? So most of us, when we think of negotiation, right, we think of like businesses and business takeovers and all this stuff. For lawyers, we're thinking plea negotiations, or we're thinking a settlement between a husband and a wife, or settlement between a guy who rear-ended somebody else, right? That's usually kind of what comes to mind, even though we know we negotiate little stuff all the time. That being said, most of us think in this competitive approach mindset, right? So we treat, generally in negotiations, the negotiation as what's called a zero-sum game. Basically, the zero-sum game says everything that they get, you lose on. Everything that you get, you win on. And then they lose on, right? So it's not like they get something and it counts as a win, and you get something and it counts as a win. It's they won something. They walked away from the table with what they wanted. Even if you walked away from the table with what you wanted, you're still not happy about it, right? It's a zero-sum game. It's everything that I lose, this person benefits. Everything that person loses, I benefit. So your goal is to get as much as humanly possible, right, out of them, which may be true, right? That might be what you're trying to do. That's the approach that we normally think of. Now, this approach can be very successful if you have a weaker opponent, right? So if you're in a position of relative power, right, or you have more money, you have a bigger office, you have whatever, you can use the competitive approach against a weaker opponent. Ethically, it's a weird area. It's kind of up to you how you feel. If you want to take advantage of the weaker opponent, right? So, for example, let's say we're talking plea bargaining, right? So a prosecutor is talking with you and your client about like a bank robbery, and the prosecutor says, I won't agree to anything less than 10 years, right? And you respond back with, the common sentence for this is only 5. We won't take anything above 5. All right. So how do we break this down? First, you're just talking positions, not asking why. Why do you want the 10 years? Right? And the why can clarify. Well, he used a gun, and your response with, no, he didn't. Okay, well, that changes things. Or I'm up for re-election. Okay, well, then let's figure out something that doesn't give us 10 years. I want my 5 years. So, give me the 5 years. We'll come up with some kind of approach. That would be kind of a creative solution. The competitive approach is, no, I want 10. And the other person responds with, I want 5. Who has the power in that room? The prosecutor, right? Because anything the prosecutor says goes, basically. So he or she, they can be very powerful over a weaker opponent, especially if that opponent's not represented by a lawyer or counsel. If it's the prosecutor saying, you plead guilty, I'll give you 10 years, when you're looking at 25 years, that sounds like a pretty good deal. You'll probably take it, right? Because the other person's in the position of power. You don't really have any room to negotiate, at least so you think. So it can be successful if you're the prosecutor, like you have the power, right? Think about something like an insurance company going up against an individual. Insurance company says, you either take our settlement offer of $5,000 or we go to trial. And I assure you, our legal team is amazing. And you don't have a lawyer, or maybe you have a lawyer, but it's like kind of the scumbag lawyer. The insurance company has millions and millions and millions of dollars at their disposal. You do not. You don't want to go to trial, right? Because you'll probably spend more money at trial than you will recover. So they're very powerful, you're very weak. It can be successful, right? You can leverage that power, and that's one approach. And again, none of these are necessarily the correct way to do it. It's very dependent upon your position, dependent upon what you want in terms of morals, ethics, etc. How you approach it is how you approach it. These are just kind of the big three. That being said, there is a word of caution I have. We're using the competitive approach. It can inflame tensions against equal opponents and freeze all negotiations, right? So if you're on a level playing field and you just stick to your position, the other party's going to stick to their position. Nobody's looking at the interests, like nobody's asking why. Then you're going to have an impasse, and there's no point to negotiate, right? I want $5 million for this. Well, I'm only willing to pay $2 million for this. Well, I want $5 million. Well, I'm only paying $2 million. Well, and like you can see, there's no point, right? Absolutely no point. Especially if you don't want to start giving up concessions. Now, that being said, the competitive approach, and really all these approaches, begin with a handshake. Now, if we were in person, I would show you how to do the handshake, because the handshake is, well, again, not now in COVID, but in the time before COVID, and hopefully at some point in the future, we'll get back to shaking hands, is one of the most important parts of the negotiation, because it'll tell you who has the power. Again, it's a subconscious thing. It subconsciously tells you who's powerful, right? So when you shake somebody's hand, you want to make sure that your hand is on top, right? That they reach out first, like you wait till they reach out, and you put your hand on top. And you shake your hand, right? With your hand physically on top of the other party's hand. Now, let's say they do something sneaky, like they've taken these courses before, they understand what they're supposed to do. They take their hand and they put it over both your hands, right? So it's like a double handshake. Your response is to put your hand over their hand, so you're on top, right? It happens in a moment. Most people don't think about it, but it's actually a very big deal. Do this with like car dealerships. It's amazing how far they'll drop down. It's suddenly sir and ma'am before, when it was kind of like a buddy-buddy thing. So again, don't reach out first. Let them reach out. Make sure your hand is on top always, right? Always on top. So that often just is, it can be just the single hand, but often might have you have to cover the hand, right? Or double handshake, whatever, as long as you're on top. Because it sends a message to that person's brain that, oh, this person's dominant, right? And it kind of starts sending like sirens and alarm bells in the back of their brain, their subconscious, that this person's dominant, maybe more dominant than I am, I don't know. That's when we start to have self-doubt, etc. So with all these, it really does begin with the handshake, but it's very important if not one of the most important points of the competitive approach. Now you can have a cooperative approach, right? Cooperative approach and the creative approach are very similar. The cooperative approach, you treat the situation as a win-win approach, right? And you do this by one party, maybe you, as a negotiator, granting unilateral concessions, right? So saying, oh, I'll give up my position on this and this in order to establish trust. But not only are you establishing trust, theoretically, and it's just theoretically, you're kind of giving them a moral obligation to reciprocate, right? So think about it as gifts, right? So let's say that you have a friend or somebody like that, or a coworker, whomever. They found out it's your birthday and they give you a present, right? It's a nice little trinket, nothing fancy, but just a nice little thing. What does that do to your brain when you find out their birthday is next month? What are you going to do? Right? Most of us would probably feel some kind of moral obligation, kind of this need to reciprocate, right? So we're going to buy them a present for their birthday. Again, it's psychological, and that's what most of this will be, is this kind of psychological approach. But this moral obligation comes into play, right? And your goal behind like the unilateral concessions, not only to build trust, but also to say, I'm giving up this and this, then they're going to feel compelled to give up one or two of their positions, right? Now, it's very important what positions you give up. And we'll talk about how you plan what you're willing to lose and what you're wanting to win. You will want to walk into a boardroom negotiation with basically a list that you've already pre-formulated of stuff that you don't give a shit about, right? But you want to make it seem like it's a big deal. So let's say that you wanted a a brand new like Maserati, right? Very expensive cars. But let's say you honestly do not care about the color, right? Like maybe that's just not your thing. You don't care, like like it's awesome interior, it looks cool, like color doesn't matter to me, right? It could be black, but black shows dirt like crazy. It could be white, that's elegant, or it could be red that stands out. Like you really do not care about color. One of the first things that you're going to pop out in there is how much you care about color, right? You're going to talk about color till the cows come home. That way, whenever since you don't care, you're negotiating on price, you can give that up, right? You can say, you know what? I feel like we're kind of reaching an impasse here in terms of the price of the Maserati. Let's go with what color you were thinking, right? You were talking about the black one, right? Yeah, okay. Well, let's go with that color. I'm willing to give that up. Well, suddenly, it might not necessarily establish trust, but it's going to do one of two things. And this is why I don't like the cooperative approach. It's one, either going to create that moral obligation for them to say, you know what? If you're willing to change the color, I'm willing to come down on price. All right, it's going to change that to a moral obligation. But it can backfire because it can make you look weak, right? And that's what we think when we talk about like this approach, is this has an inherent weakness, right? You're the first one to give something up. So the other party gives something up to them that's important to you. It makes you look weak. Like if you say, you know what, yeah, I don't really care about the color. Let's go with the black one like you're talking about. that can communicate to the other person, depending on the tone that you use, your body language, etc. I'm actually really weak. You know what? I'm tired of arguing. I'll go with whatever you want to do. Right? And so you might still negotiate, but the other party thinks, if I just keep this up, they're going to eventually kneel to me. Right? So, you know, a lot of it is how it's perceived. Now, theoretically, I mean, it should be a win-win approach. Both parties should say like they want to both maximize each one's opportunity for gain. But you can see where if you're not on the same page in terms of we both want to win, we want to help each other achieve their goal while we achieve ours. If you go in with a cooperative approach and they come in with a competitive approach, you can see how that's going to clash, right? And how the cooperative approach could appear weaker. So a lot of this is developing relationships, right? And that's how most businesses negotiate. Most businesses negotiate from the standpoint of, I'm going to do business with this other business a lot in the future. We need to have a good working relationship, right? So maybe the zero-sum game isn't how we want to approach this. Maybe we should work together. And we'll communicate that to them, that we, you know, hey, we really want to work together. We want to have a long-term relationship with you. Let's find something that gets us both happy, right? That's the cooperative approach. But you're upfront about it, and you're open about it. But if you walk into a boardroom and you think, I'm just going to use the cooperative approach, another person saying, I'm using the competitive approach, and then you start giving stuff up, you're spiraling downhill, right? So a lot of this does involve, do you want to maintain relationships? What are your pre-negotiation meetings or communications? How have they been? Have they been short? Have they been nice? How's this worked, right? So that's the cooperative approach. The approach I prefer is the creative approach, right? So creative is like cooperative, but the tension is taken out from the beginning, and that you don't have to start giving up positions. So if we think of the creative approach, think of it as it's similar to the cooperative approach, but it's characterized by a problem, by tackling a problem together, right? So you and the other side identify that, hey, we have a problem, right? I want 5 million, you want 2.5 million. Okay. We're not willing to budge, right? You don't want to issue trade or give up any important unilateral concessions. Now, so again, the ultimate goal here as well is to maximize everybody's opportunity for gain. But if you frame it as we're not negotiating, because negotiating has that kind of win-lose mentality, but if you frame it as, let's work together and find a solution that works for us. It's actually really amazing how things turn around. And again, this is psychology coming into play. When I say the creative approach, I literally mean you are on the same side. And I say that literally in terms of you go to the boardroom, sit on the same side of the table as them. Right? If you're across the table, that's adversarial, that's showing off, right? That's positioning. You sit on the same side of the table and you say, and you kind of turn your chair and say, you know what? Let's look at this together. Let's see if we can come up to something that makes us both happy. Get your goals and get my goals. So start off, tell me why you've reached this $5 million. What thought process got you there? Why 5 million? And they'll probably answer, right? And then you can start kind of more or less manipulating them once you understand their interests, right? Because again, once you're on that side with them, next step is tell me your interests. And you never want to say, like, tell me your interests straight out, but ask why. So you get past their positions, and then you can understand, okay, so they're wanting 5 because it's fair market value. Okay, well, maybe there's an economic downturn, or the market is now flooded, right? So you say, well, the reason I have two is because right now the market's flooded. Um, I want to do business with you. I want to work together with you, but I could realistically go somewhere else and get this for two, just because of the way the market is. That conveys quite a tone, right? I mean, think about what you just said. Like, I want to work with you. Like, you want that relationship, even if you don't really care. You want that relationship, and you want it to succeed, but you've hinted without being aggressive and without being obvious that you're willing to walk away, right? Maybe even if you aren't, you're willing to walk away because there's somebody else that'll give it to you the price you want. Now, in this setting, you can, again, depending on pre-negotiations and your pre-negotiation process, which we'll talk a little bit about, you can give up concessions on positions to show goodwill without giving up important interests, right? So again, this goes back to the color example. So really the big difference between the cooperative approach and the creative approach is instead of cooperating and basically coming to a middle ground, which is where we always kind of seem like we end up, right? You want 5, I want 2, let's split the difference, right? That's one way that you can approach it. But if you're on the same side and you get creative, so suddenly we're not just talking about money. Maybe this person also owns a considerable amount of real estate. You can get in the real estate business. So now you're like, well, hey, let's also talk about what your other businesses do, because I'm really interested in that, and maybe we could have a partnership together, right? And so you're generating ideas, they're generating ideas of how to tackle a problem together. So no longer are you facing each other like across the table with different interests, different positions. Now you come together with different positions, maybe the same interests, but you come to some kind of goal, right? So it's a much more, it can be nasty, but it's generally a much more friendly process and a good one if you have to keep a good working relationship with the other people in the future. So when we think about types of bargaining, again, this is just kind of a refresh. There are single issue negotiations, right? So when you're only arguing over one topic, the most common approach is distributive bargaining, right? Basically, what we talked about, more for me is less for you, right? And what's less for me is more for you. So we're wanting to do that kind of fighting back and forth to get as much as we can, right? Even if we don't really care about it. That being said, when we can expand an issue into multiple issues, integrative bargaining normally occurs. In this approach, basically the parties engage in issue trading, right? So it's like an ordering of priorities. So you kind of start with giving up the small stuff and working your way up, right? So you want to buy a Maserati. I want to sell you my Ferrari, not the Maserati. You want a black car. The Ferrari is black. So, if you can give up the brand, you can get the color that you want, right? And there's obviously a lot more stuff that happens there. So we're talking issue trading. And it does create the moral obligation that comes from this, right? Especially if it's more than one issue. Because the person on the other side of the table, if you're on the other side of the table, can always look at you and say, well, 10 minutes ago, I just said you could have this. Why aren't you working with me on this one? Like this, I should win this point now, right? So that's what we're talking issue trading is one party's given in, the other side says, okay, now it's my turn. give in. The other party gives in. Then this party gives in. Then that party gives in. And it goes back and forth, right? That's issue trading. And usually you do it on an ordering of priorities. But you have to understand what your priorities are before the negotiation, and you have to understand linkages, right? So is one tied to another? If so, maybe you can't give up that issue because it will affect everything else. And so you have to understand that. It's also important to distinguish between transactional and problem-solving negotiations. Right, so transactional, mostly what we deal with in business, right? The example I have is purchase of a boat. That's a transaction, right? You want one thing, I've got the money, I pay you the money, you give me the thing. Transaction, right? You do it every day. And you don't even realize that you're actually doing transactional negotiations all the time. Like the menu at McDonald's, that's an invitation to make an offer. Like they won't accept less money, but like theoretically, that's them inviting you to negotiate, right? So that's transactional negotiations. Then we have what's more difficult, problem-solving negotiations, right? So problem-solving negotiations, if we can negotiate, that's great. And if we can use a creative approach, maybe we can actually come to some realistic terms. But problem solving, that means somebody got screwed over somewhere, right? So you are guaranteed to get the hostile person, the difficult person to work with. I mean, it's pretty much a given, right? So when we think of this, we often think of, well, we'll try to talk to them first. If that doesn't work, then we'll sue. Or maybe we'll do mediation. We'll do arbitration, right? But they're wanting to escalate the situation, right? Saying like, well, we'll talk, but then if that doesn't work, we're gonna escalate. We don't get what we want, we escalate. So this would be something like the seller's misrepresentation, right? So the seller said, oh yeah, the car only has 4,000 miles on it, okay? But you find out the engine in the car is actually a replacement. And the engine has 150,000 miles on it. Well, that changes things, right? Imagine how ticked off you'd be. Like, that's a big deal. What's the first thing that you do in that situation? You take the car back, right? Like you show back up to the dealership and say, you lied to me. Take this car back, give me one that's not with a 150,000 mile engine. Give me one that's, the exact same as this, but what we agreed to. Theoretically, that's a problem-solving negotiation, right? But it's hostile. Cooler heads don't prevail. And what's going to happen is that dealership is going to say, screw you. You knew what you were buying. Buyer beware. You should have investigated it before you bought it. And then this buyer's going to say, you lied to me. You knew what I was asking, and you lied. So suddenly we have positions, right? Buyer beware, and you lied. It's hard to get to the interests when we're in this heat of the moment situation, right? So like, what interests do you have? Like, obviously the dealership, they want to get rid of the car, right? That's probably their interest. They want to get rid of the car because they know it's a dud, right? Nobody wants to buy a car that has 4,000 miles on it with a car that has a 150,000 mile engine on it. So they want to get rid of it, right? And then try to get rid of it at the highest price possible. You want a car, presumably used, with 4,000 miles on it, right? And the car that you like that you picked out. Your interests are, well, I travel a lot, all right? I travel for business. I need something that's reliable, something that has low mileage, something that I know is being taken care of because I take care of it, right? So that's what your interest is, not necessarily getting your money back. So problem-solving negotiations, if they happen in the spur of the moment, it doesn't end well. It always goes to court, arbitration, mediation, right? Especially under New York limit law. Basically, in New York, if your car goes, you purchase a car from a dealer and you have to get something fixed on it or serviced like 3 times in a certain period, or your car is in the shop after you purchase it for 45 days or more, you can get a full refund under New York state law of your money. It's called the lemon law. Now, dealerships always put up fights, right? So what happens is it goes under the law, it goes to arbitration before it goes to court. You file a claim in court, but then the judge says, oh, you have to go to arbitration first. So you go to arbitration, and the arbitrator listens to both sides presenting their case. We'll talk about how arbitration works, and makes a decision as to if the car is, quote, a lemon, and if the person is entitled to all of their money back and any expenses that they've incurred. So that's kind of the norm, right? I mean, that's the norm. It's just 2 angry people. And that's where you have to kind of do that peace circle with yourself and know where you're at, because only you can calm you down. That means they're a better negotiator than you are, right? They understand the problems with or the idea of getting to interest. They understand that you might not feel like you're being heard, right? So they might be able to manipulate you. So that's why you have to know yourself before you go into this. Now, generally speaking, we use a one-text approach. And what this literally means is like a one-text contract, right? So you have one contract. And if we have multi-parties to this contract with this negotiation, or there's multiple issues, what we do is we edit this contract until it's accepted by all of the parties, right? So that's how business generally runs. Well, I know we agreed to this up here, but if we're going to do this down here, can we change section A? Right? Like that's how it goes until everybody's like, yep, I'm on board. This is fine. You can use a issue by issue approach, right? Where you say, okay, first issue is color. And you negotiate back and forth on the color. All right, next issue is it needs a towing package. So you negotiate back and forth on the towing package. Well, maybe you didn't get exactly what you wanted on the towing package, but you got what you wanted on the color, right? Then you move on and you say, okay, it needs to be 4-wheel drive. Well, on 4-wheel drive, you don't get exactly what you want. So you say, you know what? I want to go back and talk about color. That doesn't happen, right? Because that issue has been settled. Right? You have both agreed that the color of the car will be black. Both agree. So once we agree, we don't go back. We just keep pushing forward, issue by issue, position by position, interest by interest. Again, that wouldn't necessarily work in business as much, because you need to keep doing business with these people, obviously, and it's a lot more complicated because you deal with all kinds of like legal issues and taxation and you name it. So that's where you kind of keep modifying and tweaking things until everybody's happy. If you go issue by issue, you could end with something that looks nothing like what you wanted. And the other party could end with something that looks like nothing like what they wanted. And you both lose, right? Unfortunately, that's how most private sales go. That's how a lot of like family disputes go, is we're going to talk about this, then we're going to talk about this, we're going to talk about this. Well, maybe we can't. Maybe we need to look at the bigger picture. Maybe we have to have all these issues at play at the same time instead of doing it one by one. Like, it seems to make sense that we would do things one by one, but if we can go back and change something after we've kind of come to a quasi-agreement on it, to help us further the rest of our contract or to further our agreement or to further settle our dispute, if it's a family dispute, then you want to have that flexibility, right? So if you're ever in the situation, go with the one text approach instead of an issue by issue approach. So how do you prepare for negotiation, right? We talked a little bit about how important it is to be prepared. So you need to first identify what is your best possible outcome, right? So if you walked into that negotiation at that moment, and you got everything that you wanted, what does that look like? In this, you'll need to identify your goals and put in a proper valuation on those goals. Like, well, I'm ordering a shipment of light bulbs. Now, we're going to negotiate because it's for this massive factory, the value or how much the light bulbs are. Well, and what kind we use and stuff like that. So what you have to do before you go in is understand, okay, what is the best possible outcome for me, right? Like, I want standard incandescent light bulbs for 4 cents a piece, right? That's your best possible outcome. That's what you want. You have to, in this instance, generally set what's called a reservation, right? Reservation is it's usually used in terms of price, right? And the money that you're negotiating. Reservation is just this concept that I will not go above a certain price, right? I can go somewhere else and get it for that price. I'm trying to get it cheaper. That's why I'm here. But if I can't get it from you, if you want me to go above 6 cents, you want me to pay 7 cents for a light bulb, I'm not doing that. I'm going with another party. That's your reservation. That's your walking away from the table point, right? Again, normally in price, but it can be other substantive things. But that you have to understand what's your best possible outcome and when are you willing to walk away? Because that's the hardest thing to do, is you might negotiate something for days and days and days, and you lose what you want, right? Like you get to that reservation point and you just keep going, right? It's hard to walk away from a table, especially if you're like the thing that you want is right there. Right? It's not like car dealerships. Like when you go on a test drive, they tell you to park the car right in front of like basically the showroom window or the door and have you look at it while you negotiate. Because it's really hard to get up and walk away from their little cubicle where you're negotiating because that car is sitting right there. The thing that you want is right there. Again, it's psychology at play, right? So you have to understand what is your breaking point, what is your reservation, and how, and affirm within yourself that you will walk away if it hits the reservation price, right? In terms of factual preparation as well, you need to identify who will be the best negotiator, right? So is it you? Like negotiating on behalf of your company? Are you an employee? Are you the president? Who's in the best position? Often engineers are in the best position, right? Because like they understand stuff that the people who run companies, like people who run companies don't understand what they make or how they make them, right? So like CEO of GE does not understand how you build an aircraft engine, right? He understands how you run a company. So it's kind of the same thing here. You have to say, okay, who is the best, it's going to be the best negotiator, right? Best negotiator, and we have to think about it in terms of our goals, but also best negotiator in terms of how they present themselves, how they build a relationship, how they actually bargain, etc. Now, a lot of people say lawyer. Lawyer is an ugly word, right? Because the minute you say, oh yeah, I'm going to have my lawyer will call you and we can start the negotiations, guess what? You've just escalated this situation out of control, right? I mean, there are some situations where you do need a lawyer for a negotiation, right? Like, I mean, if it's a technical legal issues, something like that, yeah, get a lawyer. But if you start off with, my lawyer will do the negotiations for me, the other party is naturally going to get a lawyer. And what do lawyers like to do? They like to argue, right? We argue in circles. We pass stuff off and we slam stuff on desks and I'm going to court, right? We don't necessarily have, and we're supposed to theoretically have your best interest at heart, but we also have our own interests, right? I get paid more for a trial than I do a negotiation. Well, we're going to trial. Again, it's you're escalating the situation, and suddenly it's a conversation between two lawyers who don't really even know the business or understand why they're trying to get light bulbs or for who. All they know is they can't go above 6 cents. It's lost, right? The meaning of what you're trying to get is lost. So lawyer, use them carefully. I mean, again, there are times where you bring them in, like after the fact, or during the negotiation. There are some times where a lawyer is the appropriate person to be the one negotiating, right? If you have in-house counsel and you're negotiating a trade deal, but the trade deal has some complicated customs legal issues, then yeah, you want corporate counsel there negotiating, right? But if you walk into, like there's a dispute between you and the car dealer, right? The 4,000-mile car. You will say, I'm getting a lawyer. Well, they're getting their lawyer too, right? And suddenly the parties who are best qualified to negotiate aren't, right? Suddenly it's lawyers. And then you just kind of get what you get. What you also have to do is not only understand who the best negotiator is, but you also have to identify the BATNA, right? The best alternative to a negotiated agreement, right? So your best alternative to negotiated agreement basically is, what would one want to happen if the dispute resolution fails, right? So if the negotiations fall through, what do we want to happen? This is difficult when you have companies that are so big and they have very complex operations. So again, like GE is like the world's biggest corporation. It produces everything from light bulbs to jet engines to MRIs, you name it, it produces it. So you might be working with one division of GE, right? You might be you work for a hospital and you're securing a new MRI machine from GE, right? But you also have another agreement with GE to provide like new technology, right? Like tablets and software and all this stuff to help doctors and nurses expedite their jobs. Well, what happens if negotiations fall through on the MRI, right? Like they just won't budge, you won't budge, you've reached what's called an impasse. You want to know and you want to be prepared and identify what you would want to happen if the dispute fails, right? So like if you fail the MRI, well, what about the GE contract dealing with the tablets? Do we still have that in place? Do you still want it in place, right? Because you can always, if you haven't reached a firm agreement on that, that's a separate negotiation. You can merge the two, right? Suddenly it's not just now an MRI. Now it's an MRI and the tablets, right? And it gives you a bit more bargaining room. So always identify your best alternative to negotiated agreements. You have to understand, okay, what's going to happen if this thing falls through? And that's important because it helps you set your reservation, helps you walk away when you've met your reservation, because you already have a plan B. you have a best alternative, right, to what would happen if the resolution failed. Things you should do in preparation for the negotiation also include role-playing, right? So for this course, there will be a lot of role-playing. Actually, the majority of it's going to be role-playing. So next class, we will have a role-play. I encourage the parties who will get an email, you don't know who you are yet, from me in a little bit, to treat it like it is real. Become the person, treat it like you're angry, or treat it like you're sad, or treat it however you're told to treat it. All right, so basically, our first role play involves 3 parties, right? All of you will get a summary of what the dispute's about. The 3 people that I've chosen for this first role play will get a lot more information about their person and their position that they cannot share with anyone else. Can't share with the class, can't share with the other parties, right? So it gives that realistic, like, this person's coming to the table with this person's coming to the table with this person's coming to the table with this. How do we negotiate? How do we resolve it? All right? So just know that that's coming down, but it's something that if you have time to do before negotiation, do it, right? Research is the best thing that you can do. Research their company, what their interests might be. Try to speculate as to what their interests might be, and sit down with somebody who is a good negotiator and do a mock negotiation, role play. Maybe sit in their shoes, right? So that way you have a trial run under your belt, right? So you have practice under your belt. You're not going in there completely blind, having not negotiated from their position or from their perspective. You already have. And you've already figured out what they're going to say and how they're going to say it and how you're going to respond, right? Role playing is absolutely key. In the business world, it happens a lot, right? Role playing happens quite a bit. And if you read the Getting to Yes book, the author suggests role playing, right? Instead of just doing it a lot before you go into a negotiation. Again, this is going to depend on the transaction. Like if it's a big transaction, you're probably want more role playing. If it's just a small transaction, a simple conversation will do. You also need to think about the time, the place, and the parties, right? So ideally, a negotiation should happen at a location and a place of business where distractions will be minimal, right? And where both parties feel comfortable. So this usually means a third party meeting location, right? So if I have this grand conference room and like, and you get into some of these big firms, like I was in Boston, like we had a few conference rooms, but we had this giant one, grand oak table. I mean, you had these grand chairs. It overlooked the Charles River. I mean, like it was just this beautiful thing. We used that to intimidate, right? Like if somebody said, yeah, we'll negotiate your place, you have room, we'll do that. Well, they walk in and suddenly they feel much smaller. And we feel great because we're in there all the time, right? Like it doesn't bother us. We're not distracted by the boats or anything like that. Like, we're there. Vice versa. You probably don't want to be at their place of business, right? Again, it gives that perception of who's in power, who's in charge, who's weaker, who's stronger, etc. So usually you'll find like there's services all over the place that rent conference rooms, or you might choose a hotel ballroom, right? Some kind of middle ground. And what you're doing when you're trying to figure out where you're going to have your negotiation is you're negotiating, right? So you should prepare for your negotiation to negotiate by doing these same steps. That being said, there may be issues that arise if we have a non-party's presence, right? So let's say we have an issue between a mom and a dad, right? And they're making a really tough life decision, right? Maybe whether they should get a divorce. So dad doesn't necessarily want the child there because he knows that like the child's going to take the mom's side, right? The mom obviously wants the child there because the child's going to take her side. So what do we have? If we say we're excluding the kids, no, the kid can't be a part of this, shouldn't be a part of this, this is between you and me. Well, we're just creating more conflict, right? We're creating more conflict. We're raising the tension, we're raising the stakes. However, if we include the kid, then we run the risk of creating a power imbalance between the parties. Because now suddenly it's mom and kid versus dad, right? It creates power imbalance. And theoretically, we want to be equal, right? So we have to come to some kind of understanding, preferably before we begin negotiations, as to who exactly is allowed in the room and who is exactly is allowed to make a decision. All this stuff needs to be lined out, again, negotiated prior to the negotiation. Because if you just do it spur of the moment, you're creating conflict or you're creating power imbalance, right? That being said, you still have to be flexible, right? You can't be rigid. You can't say, no, we're having it at my conference room. Okay, yeah, maybe your conference room will intimidate them, but if they're good negotiators and they do this all the time, they see conference rooms all the time. Who cares, right? So be flexible. When I'm talking inclusion, exclusion, be flexible. You have to think for yourself if this party is going to cause you a problem, or maybe this party that your adversary, again, if we're doing creative, your partner, wants to bring in, may be helpful, not only for you, but maybe to shed light on the issue, right? So you have two parties, they're arguing over an issue. One party brings in an engineer, right? Because it's some mechanical issue they're arguing over. The engineer tries to explain, like, all right, so this is what happens. This is how this works, and just goes through how the defective device works, right? Be flexible. I let that person in, right? It's a sign of good faith. It's not a major concession, and maybe it helps you understand your position better. Maybe you should also get your own engineer just in case, and it shows goodwill, right? So again, try to be flexible, but understand that exclusion is conflict, inclusion is a power imbalance. Not in every instance, but in quite a few. So again, we're just talking about the preliminary negotiations. This is time that you learn the other side's position, hopefully get to their interests. You confirm facts, you introduce outside standards, right? So, well, we're gonna agree on the price based upon Kelley Blue Book, right? That's an independent standard, whether it's a standard we agree upon. And potentially making initial offers, right? So as it gets closer to the negotiation, say, well, you know what, if you want to, like, so we don't have to negotiate, what if we just do this, right? You make an offer. Offers should not be too extreme or too conservative, right? They'll usually say no. The other party usually will want to negotiate because you're kind of basically just restating your position, not in an extreme way or too conservatively. Because if you go too extreme, the other party's can be turned off and be more likely to be hostile. And if you're too conservative, then you're getting taken advantage of, right? But what this does is this allows us, if we get an opening offer, to assess the reasonableness of the other party, right? So if they're saying, you know, we want $10 million, and realistically, the thing you're arguing over is worth $35,000, and their opening offer is, we'll lower it down to $9 million, you're probably going to say, hey, this other party's not reasonable, right? And that tells you a couple of things. Maybe how to manipulate them when you get into the session, that they're going to be a difficult person. And it might tell you that you might need to walk away, right? Walk away from the deal. Then when formal negotiations begin, you have to keep in mind concession, how frequently they're made and how much is conceded, right? With that reserve in the back of your mind. So that being said, one party may feel intractable on one issue, but is willing to concede on another. You have to explore it, right? So they're like, yeah, I can't change it on this, but I can change this. Well, let's go down that path, right? Because they're willing to go down that path. Let's go down that path. And if we don't like it, we reach an impasse, we can move on to another issue and return to it later. Or we can, maybe something down the road will change their mind on the first issue, right? So again, if we use the cooperative method, brainstorming is often helpful. And this is true of the creative method as well, right? You brainstorm together to figure out how to resolve impasses when you just can't agree. You have to also be ready to reevaluate your goals, your reservation price, and your best alternative, right? And you have to do this throughout negotiations on a rapidly moving basis, right? So this isn't, I'm just going in here with a stuck mindset. This is, well, maybe this goal isn't as important to me as I thought it was after hearing their side. So I can give on that a little bit, but I'm not giving on this other one, right? Or this has to change a little bit, but this other thing can't change. So you have to be flexible, but you have to be able to keep moving and think quickly. Because you could be talking about one issue, and then maybe there's 2 or 3 people in the board on their side, 2 or 3 people on your side, and somebody says something that's completely off topic, and you go down that rabbit hole. Well, that might change how you think about something else that you're going to negotiate, right? So you have to constantly be thinking, how do I get the most out of this? But when do I walk away, right? So you have to kind of keep exploring that. This is just a quote I pulled from the book. I thought was great. The quote says, "The bargainer who is willing to wait long, to probe more patiently, to appear less eager for a settlement will be more successful. Many Americans are uncomfortable with long pauses and the give and take of negotiation. They feel obliged to say something, anything, to get the negotiations rolling. However, it's not what is said in a negotiation that counts, but what isn't said. Very often, the strategic essence of a negotiation exercise is merely a waiting game with self-imposed penalties, embarrassment, for delay." Right? So this is the idea of the handshake, right? You don't reach out first, they can reach out first. It's, if you appear that you want to settle this and you're excited and you kind of have that overly excited tone, they're going to take advantage of that. You have to be willing to wait, right? Wait on that car. Say, you know what, I think I'm going to have to walk away from this vehicle. Guarantee you 2 or 3 days later, you're going to get a call and they're going to cave on the price, or at least come down substantially, right? Because they have incentive to sell. Like they want to sell the car because they get a commission. But they would rather take a lower commission than no commission. And in American culture, we all feel obligated to fill that weird pause. So let's say somebody makes you an offer while you're negotiating. Don't say anything. Act like you're thinking about it, but sit there and just kind of stare at the other side. Sit there quietly. Because if you do, they're going to get really uncomfortable. Right? Again, this is presuming that you're dealing with Americans. When they get uncomfortable, they're going to say something. They're going to tip their hat. They're going to show you something. They might come down on price again. Whatever it is, just to get negotiations rolling and the ball rolling. Right? So this might even be walking away for like Say, hey, you know, I think we should call it a day, and it's like 2 in the afternoon. Let's call it a day. Maybe we should resume negotiations in a week or so. You have to be willing to wait, and you can't reach out first. Party who reaches out first loses, right? Again, this is assuming a win-lose scenario. It's because they're uncomfortable and they want to settle, and that tells you, oh, they're really wanting to get this done. Well, my price just went up, right? Because they're trying to settle this. So I have incentive to take more than I normally wanted. So again, it works with car dealers a lot. Like if nothing else from this course, understand that you want to manipulate a car dealer, walk away. Like they'll have your phone number and stuff, like just walk away. A couple days, they'll give you a call and that car will suddenly become a lot cheaper. Just something to think about. We're talking about closing negotiations. Closing is complex. If we have complex issues or numerous issues or more than one party, generally we're going to have more than one negotiation session, right? So we shouldn't expect to finish things in one negotiation session. Doesn't happen. Complex negotiations are more easily resolved than single negotiations because you have more room for what's called horse trading, right? The bargaining. Well, I'll give up this if you give up that. If you're talking about a single issue, you can't give up anything, right? If you give it up, you've lost, and you don't want to lose. That being said, once an issue is resolved, it shouldn't be revisited unless absolutely necessary to resolve a more important issue to the party. Now, this isn't we're doing one at a time and then we're done with it. This is that one document. We should generally try not to go back and revise other stuff unless we actually have to because of something that we just negotiated. That being said, negotiated agreements are generally considered a contract and they're enforceable in civil lawsuits. However, no mechanism exists for transnational agreements, right? It's the idea of linkage of like between your company and ongoing trade, et cetera, is vital. So let's say that you're an American company and you're doing business with China. And you come to an agreement. You have a contract. And then the Chinese company backs out. Not a whole lot you can do. I mean, we have trade courts and things like that, but that's usually more reserved for governments. You could try to file a lawsuit in China, but guess who's going to win? Right? Maybe the same thing if they try to file a lawsuit in the United States. Guess who's probably going to win? I'm taking that to a jury trial. Right? And I'm finding the dumbest jurors I can who are going to vote for me. So again, in the United States, we sometimes we have an enforcement mechanism. International, transnational, we don't. In criminal law, if we're talking about negotiations, plea negotiations are normally binding and require what's called specific performance. So if the prosecutor goes back on his or her word, the party can object to it, and the court will require that the prosecutor fulfill everything they said they were going to do. Right? Specific performance means you have to do whatever you agreed to do. Now, contract law, we see specific performance. If we want specific performance, we ask for it. But a lot of times we're suing for money damages, right? Like, oh, you wasted my time. Yeah, I want my money back. I want all that jazz. Rarely will you have punitive damages. So the last thing I'll talk about is just an essential negotiation skill, right? It's reflective listening. So this is what I was saying earlier. Restate what the other person has said and obtain their affirmation that your understanding is accurate. This is especially true if they're a difficult person, right? So what you're saying is you think these proceedings are bullshit. So you don't like being here, right? Am I understanding that correctly? Right, so restate what they said in a non-judgmental language, which I just demonstrated, right? Not being aggressive, not being too passive, but being clear. Ask the speaker to clarify what they've said, right? So again, this is, so why do you believe that? Or help me understand, how can we make these proceedings feel like they're not valid or they're not bullshit? How would you like us to change or see what we can do? Right? And keep the demeanor and the tone of your voice calm, right? Because you're talking to somebody who's probably irrational. You can calm them right down with a calm voice. But you always have to use I language. Never, well, you said that this, and you said that this. No. Oh, I thought I heard you say this, or I thought I misunderstood, right? You use the I language. Because if it's an I, it's not an attack. It's you just getting clarification, right? And basically sending the message of, oh, we're not on the same page, but I want to get on the same page, so let's talk about how we get on the same page. Nonverbal communication is huge. How you sit is very, very important. Where you sit, how you keep your hands, do you talk with your hands? All these are very important things. And you can have a whole course on nonverbal communication, right? If you're talking to somebody and they cross their arms, you're wasting your time, right? Because once they've crossed their arms, it's basically a nonverbal communication of I'm closing it off. I'm closed to this idea. They may open up when you go to a different idea, but if they sit there with the crossed arms, you know you're not getting what you want at that point. So maybe shift your communication, shift something, shift your issue, and then come back to it, all right? You don't usually have eye rolling and like negotiation, the formal negotiations or anything like that. But somebody who stands, right, when they're talking, obviously comes across more powerful. But you don't want people standing because that leads to potential violence, right? So again, nonverbal communication, just be cognizant of what you do with your hands, with your eyes, with your mouth, and understand that you do have ethics to apply to, right? If you go with the competitive approach, you still have ethical obligations, right? You don't want to leave the table winning everything that you want, but selling your soul for it, right? Understand that we all have a threshold, right? Lawyers have a code of ethics that we abide by. You should practice the same, even if your other party doesn't. Right? If they're being unethical, walk away. Right? That's always your go-to. You can always walk away. So I would do the talking circle, but I see we're out of time. I appreciate you listening. The parties who will role play next meeting, so next week, I'll send you your parts now, and I will post on Canvas now the summary of what the dispute is about. So if you get a part, don't share it with anybody. Don't pre-plan it or anything like that. Get into it, do some research, whatever you need to do. Come in prepared on Tuesday. Come in prepared swinging, right? Come in prepared, but using the tools that we just walked through. And again, this gets posted on YouTube, so I encourage you to watch it over again, just getting more ideas on how you should approach a negotiation. Okay? So again, thank you for watching, and I will see you Tuesday. Have a great weekend.